First of all, let me greet the organizers, distinguished speakers, and our engaged audience a pleasant good morning. We are indeed fortunate that the Department of Foreign Affairs had organized this historic webinar in partnership with the Philippine Society of International Law and the Philippine Association of Law Schools. Let me also congratulate our two speakers, His Excellency Ambassador Enrique Manalo and Professor Andre Raj Palacios, on their respective lectures. They have given us privileged vistas, diplomatic and academic respectively, from which we can look at Philippine engagements with the UN. I have entitled my response to the lectures, The Philippines and the UN, Understanding the Direct Effect of International Law, Rediscovering Filipino Legacies. And here I make three related points for taking their insights into particular directions. Now on to my first point, direct effect, the Philippines and the UN Security Council resolutions. The complexities of our engagements with the UN may be illustrated by Philippine commitments to the UN Security Council resolutions issued under its Chapter 7 powers. The textbook approach is to say that international law is transformed into Philippine law in two ways, via the Monist Incorporation Clause or via the Dualist Treaty Clause. Elsewhere, I have proposed a revision of this two-factor approach, outlining what I call five other entry points or modes of direct effect of international law. These are namely the Supreme Court's prerogative writs issued under its rulemaking powers, a direct effect by constitutionalization, direct effect in the state of exception, direct effect by judicial notice, and direct effect by statutory application. Direct effect goes into the political and dual functions played by domestic courts in international legal processes, either as a shield denying the application of international law into domestic disputes, or as a sword piercing the domestic legal order for the protection or recognition of rights. As we know, UN Security Council resolutions issued in matters of international peace and security are considered binding on states parties. But how exactly does that happen in the Philippines? Thus, we come upon what is ostensibly an eighth mode of direct effect of international law in Philippine jurisdiction. That is, giving effect to UN Security Council resolutions through executive orders. The earliest example I could find of this legal phenomenon is Executive Order number 126 from 1968. EO 126, issued by President Ferdinand E. Marcos, imposed economic sanctions on the apartheid state of Southern Rhodesia pursuant to UN Security Council Resolution number 232 from 1966. A more recent example is Executive Order number 138, issued by President Benigno Aquino III in 2013. The 2013 EO is based on UN Security Council Resolution numbers 1883 from 2009 and 1998 from 2011. These deal with the situation of children in armed conflict and of the need to integrate post-conflict recovery and reconstruction planning programs and strategies. A ninth mode of direct effect, also involving UN Security Council resolutions, is through a government body created by statute. In this case, the Anti-Money Laundering Council. The Council keeps a tab on the UN Security Council sanctions list, which identifies individuals and entities subject to assets freeze, travel ban, and arms embargo. The UN formally relays the sanctions list to us through the Office of the Philippine Permanent Representative to the United Nations in New York. That is Ambassador Manala's office. Given that these EOs and resolutions did not pass through the procedure outlined in the treaty clause of the Charter, the first question that comes to mind is on the constitutionality of this mode of giving direct effect to international law. And we are not even speaking yet of due process and other substantive considerations. In any case, our Supreme Court now has its very first opportunity to rule in this question. I'm referring to the pending petitions against the new Anti-Terror Act of 2020, Republic Act 11479. Under Section 46 of the Anti-Terror Act, an Anti-Terrorism Council is established. The ATC is empowered to take on relevant resolutions issued by the UN Security Council acting under Chapter 7 of the UN Charter, as well as on foreign requests to designate terrorist individuals, associations, organizations, or group of persons. Now to my second point, the UN human rights mechanisms in the Philippines. Let's take the case of the International Covenant on Civil and Political Rights and its optional Protocol 1. We are parties to these two international documents. The UNHRC is a body of independent experts that monitors compliance by states parties of treaty commitments. Optional Protocol 1 allows nationals of states parties to file complaints against their own states for violations of their obligations under the ICCPR. The committee issues what are called views on these communications, but these views are non binding. Two cases I had helped litigate come to mind. In Adonis versus Republic of the Philippines, the UNHRC held that the Philippine criminal libel laws violate Philippine obligations to free expression under Article 19 of the ICCPR. However, in the Decini case challenging the constitutionality of the Philippine cybercrime law, including its provisions on cyber libel, the Supreme Court refused to give direct effect to it, saying that the Adonis view does not oblige the Philippines to implement it. Wilson versus Republic of the Philippines questioned the torturous conditions in Philippine jails. The UNHRC affirmed the application, but in a mandamus suit, the Supreme Court pushed back against compelling the government to implement reforms in Philippine jails. Instead, it held that UNHRC views issued under the first optional protocol are not part of the ICCPR as a treaty and therefore non mandatory. Thus, we go back to theory and to the point raised by Professor Palacios about the special status of the UN as an international organization. Is it better to conceive of our treaty obligations as one arising from part-whole relations within the UN system, one in which states lose their individuality and autonomy to the greater whole? To my third point, human rights, a Philippine post-colonial achievement. And here I connect to Ambassador Manalo's presentation. Not too long ago, Marty Cosconemi, borrowing from Milan Kundera, warned against international legal institutions being turned into kitsch. He meant that knowing their European roots, these institutions must not be thought of as automatically expressing anything universal, because according to him, more often than not, they are used as instruments in hegemonic struggles. His remark is echoed by contemporary complaints about the weaponization of human rights, directed against states seeking to carve their own path in today's multipolar or multi-civilizational reordering. Yet all that we need to do is dig up the archives of the UN to see how the Philippines and the diplomats of the so-called golden age of Philippine diplomacy had led the world in weaponizing human rights in quite another sense. By that, I mean actually promoting human rights as a universal value that respects neither East nor West, North or South. Carlos P. Rumulo, eminent dean of Filipino diplomats, is a figure whose shadow looms large over the emergent post-war movement of third world states. Not only did he successfully propose the inclusion of the word independence in the UN Charter and therefore open the world to the recognition of the right to self-determination, he also stood tall in the campaign for the establishment of the Universal Declaration of Human Rights, or the UDHR, in 1948. Indeed, recent scholarship places CPR, as Rumulo was called in the DFA, and the Lebanese Christian philosopher and diplomat Charles Malik as two key third world leaders instrumental in the founding of the UDHR. By the 60s, the Philippines was one of the third world states campaigning to establish mechanisms to implement the promises of the UDHR. Moreover, the Philippine Supreme Court would quickly catch on, being one of the first, if not the very first in the world, to rule that the UDHR provisions are binding on all states as customary international law. Very few people realize today that the individual complaints mechanisms of the ICCPR were in fact born out of a Philippine proposal and successfully pursued in the UN by another brilliant Filipino diplomat and Romulo protege, Salvador P. Lopez. S.P. Lopez, also a foremost literary critic of his generation, and like his mentor, a former president of the University of the Philippines, served as the first chair of the UN Commission on Human Rights. The commission was the very body tasked with developing the UN human rights system, including the drafting of the UDHR. It is the predecessor of today's Human Rights Council. But any discussion of CPR's legacy would not be complete without a careful look at his role in the path-breaking April 18 to 24, 1955 Bandung Conference in Indonesia. Bandung is recognized as an anti-colonialist gathering of decolonized or decolonizing states. It paved the way for the birth of the non-aligned movement in 1961. In fact, a 2017 Cambridge University Press book on the Bandung Conference by critical legal scholars speaks of that spirit of Bandung that challenged for the very first time the well-entrenched imperialism in the international legal order of the time. Yet what is missing in this critical account is a recognition of the important roles played by Malik and again by Romulo at the Bandung Conference. Both of them were present as anti-colonialist, anti-imperialist advocates, but also as the loudest voices for the universality of human rights. The two of them fought tooth and nail for the inclusion of key language in the conference's final communique that substantively acknowledged the UDHR as a founding document for a new international legal order. Perhaps it was Romulus' classical liberal anti-communist stance that did not endear him to the scholars who had contributed to the 2017 Bandung book. It is striking to note that Romulus' most referenced book on the conference, The Meaning of Bandung, is not even referenced in the book editor's introductory essay. Given his personal and professional history, it would be easy to dismiss Romulo at this point as no more than an all-American lackey. The reality is more complex than that. The records show that at Bandung, Romulo sought a dual negation of the dominance of the First and Second Worlds and the condemnation of all forms of colonialism and deprivation of civil and political rights. In his own account of Bandung, he documented tangling with the Chinese premier Zhou Enlai, who argued that there's only one colonialism that needs to be rejected, that of the West. In the end, as the final communique would put it, Bandung radically redefined colonialism, affirming that alien subjugation, domination, and exploitation constitute a denial of human rights. What lessons may be derived from this remarkable Filipino contribution to post-colonial international legal history? Let me offer two of them. In this age of the rise of new powers, the Philippine legacy of universalizing human rights drawn from its own colonial experience sharply contradicts contemporary weaponizing narratives. Given the Filipino contributions to the development of human rights in the international legal order, the dichotomies made between human rights obligations and state sovereignty requires a serious rethinking. Second, human rights is deeply intertwined with the very character of sovereign states. This speaks to what has been called the normative peculiarity of states. And this idea has to do with the fact that the state remains to be the most immediate institution there is to people's daily lives in terms of the protection and enforcement of rights. Thus, every effort to advance human rights without changing the state's function and identity will lead to failure. Paradoxically, or perhaps inevitably, the failure of state structures to protect human rights may invite international or regional solutions. Yet, that such an invitation to the international legal order may at all be made, we owe to our own fine diplomats, who by their labors had established sure footing for the UN human rights system as we know it today. Thank you.